There's John Wheeler, I do believe.
John's back. Okay, well, we'll go ahead and get started and hope Susan joins us here in just a second. So I will call this Monday, May 18th meeting of the House Judiciary Committee to order. We will begin with Natalie going over the COMA guidelines for us.
Thank you, Mr. Chairman. This is Natalie Scott from the Office of Revisor of Statutes. Due to health and safety concerns, members of the public are not in attendance at this meeting, but full access to this meeting is being conducted by a medium of interactive communication, allowing members of the public without cost to listen to the meeting through the use of live stream audio broadcasting on the internet and teleconference as available. The video link can be reached at www.ks.legislature.org, selecting the audio video link and then the State House Live and Archive. The agenda for this meeting has been posted on the KS Legislature's website. It was also included with the notice of this meeting and may be requested from the Office of Revisor of Statutes using the Office of Revisor of Statutes official website at ksrevisor.org. Any other documents presented during this meeting will be available on the website and also from the Office of Revisor of Statutes. Each member of the committee and staff will state their name and title each time the individual begins speaking or voting so that the individual can be readily identified by remote listeners. All participants are required to ensure that microphones, phones, or other electronic devices are muted when the participants are not speaking so that the ability of remote listeners or observers to hear the proceedings is not unnecessarily impeded. Public comment will not be allowed at this meeting other than what's on the agenda. During the committee meeting, the committee will not recess to a closed or executive meeting pursuant to KSA 75-4319. Each motion, if any, will be clearly stated before the committee, and the chairperson will announce the results of the final vote. And audio will be available on the legislature's official website within 30 minutes of the adjournment of this meeting for members of the public to review.
Thank you, Natalie. Any questions for Natalie over our rules? Okay, seeing none, I will call roll and Kathy will keep track of that for us. I'm Representative Patton and I am present. Representative Ralph?
Present.
Representative Carmichael?
Present.
Representative Berquist? He's present but muted.
Present.
Thank you, sir. Representative Burris?
Present.
Representative Curtis?
Present.
Representative Garber?
Present. Present. Present.
Gotcha. Representative Heiberger?
Present.
Representative Hoheisel?
Present.
Representative Humphreys?
Present.
Representative Jennings?
Present.
Representative Keither?
Present.
Representative O'Hobbesum? He is here. He's muted. He texted, oh, he's unmuted. You still here, Casey? Well, I'm pretty sure he's here. Representative Owens.
Present.
Representative Samsel.
Here.
Representative Warren.
Here.
Representative Wheeler.
Present.
Very good. And Kathy, all committee staff is here. And in addition, we have our invited guests and a number of other legislative staff appear to be on the call. Okay, so committee, first item on the agenda, I just left it on there from last week, was a discussion of COVID-19 liability. I know, again, discussions are taking place. I've gotten some updates over the weekend. I did listen to Senate Judiciary today. They had a similar hearing as like the one we had on Wednesday. I don't know what their next step is, but anxious to hear what the Senate plans to do. Like they are done for the day. They meet again tomorrow. So just encourage you, if you've got time, to go back and listen to that. It's not live streamed on YouTube, but you can go back and listen to it on the Harmony link on the legislative website. So encourage everyone to do that, so we kind of, as we move forward, we know where they're at and what things are shaping up to be like. The other item is review and discussion of state of disaster emergencies, emergency orders and proclamations, and other related issues. As you'll recall, Natalie Scott did a good job on Friday laying down some groundwork for us where we are and who has what powers, what the executive orders are that are already in place. Today, I've invited the Attorney General and the Governor's Chief of Staff to come visit with us. I appreciate them both for being here. This meeting was a little bit up in the air. Originally, I was going to do it Friday, and then I tried to do it Tuesday, and that didn't happen, so we're going to do it today. So I appreciate their flexibility. As I shared with you on Wednesday on all of our hearings, it's really just educational in nature. We're laying the groundwork, trying to see what the Senate's going to do, try to figure out where we're headed and when the full legislature returns on Thursday. Gonna call them both, let them visit with us. We will have the opportunity for some questions, but this really is not the chance to criticize past actions, criticize conduct. This is to talk about where we are and how we're going to move forward. We need to have a plan. We need to do something on Thursday, and this is just one more step in how we're going to get there. Whether we like it or not, we've all got to work together to come up with something so we can do what's best for Kansas, and this is just one more step as we move down that path to see what option we want to pursue. So, any questions about any of that? Representative Keither.
Thank you, Mr. Chairman. Annie Keither, Topeka, 55th District. I do have a bit of a concern that this is our final meeting and that the Senate will meet not only tomorrow, but again on Wednesday. So that leaves this committee sort of hanging with no real sense of how to really work together if that's really the end goal. So I have some real concerns about how this is going to all play out.
Yeah, and I can't disagree with that. I mean, I wish we had more time and time for more meetings. And let's see what happens. If we need to meet again or figure out a way to work in another meeting, I will certainly go to leadership and try to make that happen. So stay in touch with me. Let me know your thoughts and concerns, and we'll try to figure out best we can to at least have our side have a plan as we move forward.
Okay, thank you.
Okay, not seeing any other questions. I am going to turn it over to the Attorney General. Thank him for being here, and the floor is yours, sir.
Well, thank you, Mr. Chairman, and it's good to see everybody. We've missed you here from the Topeka bunker these last several weeks, and I'm glad you're going to be able to make it back, albeit under unusual circumstances. Mr. Chairman, I don't know, precisely what is most useful to the committee. I will tell you what I have in mind, and I'll either do that or I will do something different if you tell me something different is more helpful. Obviously, we, along with the governor's office and the Division of Emergency Management, particular legal staff, and many other interested parties, have been sort of up to our eyeballs in the Emergency Management Act and its application over these last several weeks. And, from our vantage point, at least in the course of doing that, we've spotted some issues that probably deserve some public policy attention. Some of them may be longer term. Some of them may be shorter term. I don't necessarily express a view on which might be which, or even if ultimately they all or almost any of them need to be addressed. But I think because we've spent so much time immersed in these statutes, particularly the state statute, Chapter 48 statute, just offering these thoughts up might be helpful as you all figure out, what, if anything, you're going to do legislatively on Thursday. So my plan was just to maybe talk a bit about, almost in an issue spotting sense, some of the items we've identified that might deserve some attention, if that's agreeable, Mr. Chairman.
Sounds good. Thank you.
All right. There's no particular order to this. These are the items I wrote down earlier today, knowing I was going to be having this conversation with you. And I'll give the quick disclaimer, it may not be an exhaustive list. There'll probably be something else that after we get done, I'll think I wish I'd shared that with them. But this is what I have at this moment. I wrote down 9 items that are issues that might be worth policy discussion at some point. Item number one is, I think, very particular to our current circumstance. And that's this. Let me back up just to be sure everybody's on the same page here. In order to access and exercise the emergency powers that are authorized by the KEMA, the Emergency Management Act, particularly in 48.925, the condition precedent, of course, is that there has to be a declared state of disaster emergency under KSA 48.924. The governor has the authority to declare that emergency based upon certain findings that are set out in the statute. They're pretty general. It's a very broad authority. But the existence of that state of disaster emergency is a condition precedent to the exercise of any of the powers that are accessed. And so issue number one that's been talked about a lot is how do you make sure that the states of disaster emergency that have been declared since March 12th under this statute by the governor are, for lack of a better term, legally infallible. I don't think there's been much discussion, debate, or dispute about the first proclamation on March 12th. I'm not sure there's been much debate, although there has been some, about the action you all took before you left in House Concurrent Resolution 5025 to extend by concurrent resolution that initial state of emergency through May 1st. But there has been quite a lot of discussion about what happened next. Obviously, there was one set of mechanisms that you all tried to put in place or did put in place before you left for LCC extensions that became unavailable after the Supreme Court's ruling in the Kelly versus LCC case. There were no other mechanisms in the statute that were readily available to extend that state of disaster proclamation, in part because you all weren't in town to vote on another concurrent resolution. And the State Finance Council mechanism was unavailing based on the facts and the timeline. And so the governor on April 30th issued a new proclamation of a new state of disaster emergency, which has now been extended by the action last week of the State Finance Council through, I believe it's May 26th. The reason I raise all of this is there's a legitimate debate about whether the governor had the authority to issue this successive state of disaster proclamation, essentially arising from the same disaster. And, I can articulate an argument in favor of that authority, as I know the governor's team can, because I've heard them do it. And I can articulate an argument against that authority. The bottom line is that it's not clear cut. And so assuming that you all want to be certain that the emergency powers have been lawfully exercised at least since May 1st, there may be some wisdom in considering whether you essentially bless or ratify by statute the existence of that continuing state of disaster emergency that started on March 12th. There is some precedent for that. After the Greensburg tornadoes, the legislature adopted a specific statute related to the Greensburg emergency and the emergency in some of the surrounding counties. That's codified at 48-924 a. And part of that statute does essentially, by statute, codify, at least formally recognizes and implicitly codifies the state of emergency that had already been declared by the governor and extended in that case by the Finance Council, and I believe also by the concurrent resolution of the legislature. So that's issue number one. You may want to look at that, because if you decide to codify that retroactively, if you will, it would take off the table any reasonable potential for somebody who's disgruntled by any one of these emergency orders that have been entered. And I think we're up to 30 now that the governor's entered under authority of the KEMA since the state of emergency was declared March 12th. Somebody's going to be disgruntled at some point, and taking off the table the argument that the order was invalid because there wasn't a lawful state of emergency in place would at least eliminate one area we might have to litigate. So that's issue number one we've spotted and we put out for your consideration. Issue number two, currently, assuming the current state of disaster declaration was lawfully entered and has been properly extended by the Finance Council, it expires by its terms under the Finance Council's action after May 26th. Presumably, we're not going to be out of the woods after May 26th, and it will continue to be necessary or desirable to exercise some further emergency powers after then when you all are gone, possibly, probably, maybe hopefully, for the balance of the year, because you will have adjourned sine die. And so issue number two is you may need to consider, may want to consider some mechanism that allows continuing extensions of a state of emergency beyond that date. Obviously, you attempted to put in place a mechanism to that effect before you left in March. That was the authority of the first Finance Council and then the LCC and House Concurrent Resolution 5025 to do these rolling extensions. That proved unavailing after the litigation. And so there's not currently a mechanism for those sorts of extensions. I would think you might want to consider creating some type of a mechanism for those sorts of extensions. I might add, in the statute itself, there are, I believe it's in 924, there are those different subsections that talk about different types of disaster emergencies. And there are provisions, I think I should have brought them, I don't have them in front of me. I think it's in subparagraphs 2 and 4 that relate specifically to animal health emergencies. They provide a mechanism by which the Finance Council can, on a 30-day, up to 30-day rolling basis, provide for additional extensions of that type of state of emergency. And I might just share a little bit of background on that piece. As pure coincidence would have it, actually I think Gordon was the author, the reviser, but I was the legislative author of that provision and carried it on the floor in 2002. The reason we did that, we'd been working on a state response, first to BSE, mad cow disease, bovine spongiform encephalopathy. And then of course, 9/11 came along and there were concerns about foot and mouth disease or other forms of bioterrorism that could affect particularly the beef industry in Kansas. And as part of that debate, we enacted legislation in 2002, which was broader, but it contained those amendments to 48924 that specifically recognize when you're dealing with a widespread health emergency, in that case, an animal disease, it's likely to last a while and it's likely to require some potentially intrusive government actions. And so, the compromise was create this mechanism that allows for rolling extensions, but do it in a way that requires some oversight through the Finance Council, not less frequently than every 30 days, so that the government actions have to be justified, if you will, to the Finance Council or members of the legislature on an ongoing basis. That was the concept. I only wish in hindsight we hadn't limited it to animal diseases, but at the time that's what we were focused on. And so that's why that exists. So you may want to look at creating some type of mechanism to provide some type of analogous extension ability and oversight in the current public health, human health pandemic. Issue number 3 that we've spotted is closely related to that. Again, you all attempted to create a mechanism in 5025 that would allow some type of oversight of individual emergency orders that are issued to execute the emergency powers that are accessed under 48925 because there is a state of emergency properly declared under 48924. That mechanism that you put in place, again, is invalidated in the judicial action, or at least it was invalidated. It was made unavailable in the judicial action. But the principle of some type of legislative review is baked into the statute itself. It's just that the way it's baked in, if you're not here as a full legislature, it's impossible for you to exercise. And that's the provision in the statute that provides that any one of the emergency orders may be the governor can be ordered to revoke any one of the emergency orders by concurrent resolution of the legislature. So the statute itself, plus your actions in March, contemplated the idea that there would be some type of oversight ability for these individual orders. At this moment, I'm not sure there is. And beyond that, you know, this isn't just, I mean, in one sense, it's a policy question. To that extent, it's entirely, obviously, your call whether you want to have that oversight. But we also know now a little bit more than we did when you left in March, because in the Kansas Supreme Court's decision in Kelly versus LCC, Justice Stegall, in his concurring opinion, suggests that having a fairly liberal interpretation of the legislature's ability to conduct ongoing oversight of how any governor, uses the emergency powers may be relevant to the overall constitutionality of the Emergency Powers Act. In other words, if there is no ongoing sort of restraint or check on the governor's use of powers, he seems to imply that it would at least present the question of whether the legislature has unconstitutionally delegated too much legislative power with no oversight and no check to the executive branch. Now, he says that in a single sentence. I don't want to spin too much into it, but he did see fit to suggest it, which suggests that there is at least a legal issue that may be raised in the event you don't see fit to create some type of ongoing oversight mechanism. Issue number 4 that we spotted and would just lay out there, and I'll actually do 4, 5, and 6 together as a group. And I'm quick to say, on none of these am I suggesting I really think you must do this. I'd come the closest on please confirm the validity retrospectively of the state of disaster emergency, because I mean, what's done is done, and I'd really prefer not to have to litigate whether it was done properly or not. But setting that aside, you know, I'm not advocating for you to do these things, at least not at this point. I'm spotting issues, and that's true in spades of the next 3 things I want to mention, but I'm going to mention them because we've spotted them. There are 3 provisions in the KEMA, the relevant parts of the KEMA. I think they're all in 925, if I remember right, 925B, that might cause one to raise an eyebrow in terms of, well, might cause one to raise an eyebrow. I'll just list them and then we'll go on. Issue number 1, there's a provision in 48924B that says essentially as follows: emergency orders issued by the governor during a state of disaster are null and void at the end of the disaster proclamation, unless extended or ratified, something to that effect, by concurrent resolution of the legislature. And that's all it says. That language looks to us like it seems to create the ability to take an emergency order and extend it potentially indefinitely. Not that anybody's doing that here, but nonetheless, the language on its face seems to suggest that could happen after the emergency is passed, because the state of emergency is dissolved, and merely by a concurrent resolution of the legislature, that order would continue to have the force and effect of law. It's really difficult to see how that method of creating something outside a state of emergency with the force and effect of law can be consistent with how laws are made under Article 2 of our Constitution. So it's probably at some point worth taking a look at that to figure out whether it's mechanically sound. The second issue, in a similar spirit, the Emergency Powers Act, the provisions at issue were enacted in the first instance, and most of their provisions date to their first enactment in 1975. It's a 1975 statute. The basic architecture of the statute, which is more or less the governor declares a state of emergency, and during that state of emergency, the governor may access these legislatively delegated powers subject to legislative oversight and ending at the end of the state of emergency. I mean, that's the fundamental architecture of the statute. That was created in 1975, but 9 years later, in 1984, the Kansas Supreme Court decided Stephan versus House of Representatives. And in the Stephan case, the Kansas Supreme Court found unconstitutional as a violation of the Constitution's separation of powers, the use of a legislative veto by concurrent resolution to block an executive branch action. In that case, the legislature had adopted a statute that was designed to increase oversight of how regulatory agencies issue rules and regulations. And the idea was the legislature would review individual rules and regulations and could revoke them one by one if they chose to by concurrent resolution. And the Kansas Supreme Court said our Constitution does not allow that mechanism for oversight, for revocation. Essentially, I'm overstating it a bit, but essentially once the power has been properly delegated to the executive branch, the legislature can take it back only by law and not by a concurrent resolution. Now, there's a legitimate argument whether that holding applies here as well. There obviously are differences between an emergency power of the governor exercised by statute and a regulation exercised by an administrative agency. So there's room for discussion, but it probably is worth looking at some point about whether the oversight mechanism that's built into the statute is consistent with how our Supreme Court now interprets legislative veto. Next item, the third in this trilogy, is a specific issue with 48925B of the statute. There are a couple of possible readings of one provision in that paragraph, that section. One, which I think has been, I don't know if it's everybody's reading or not, but it's been largely the practice, maybe even exclusively the practice, but largely the practice to my knowledge during the current state of emergency, is that 48925B authorizes the governor to issue orders and proclamations, but orders that have the force and effect of law. But the practice has largely been that the subject matter of those orders has been confined to this enumerated list of subject matter that's in the next subsection, subsection C, 1 through 11. And I think that's a good practice. But just a plain reading of 48924 or 925B doesn't necessarily lead to the conclusion that the orders that may be issued under B and have the force of law must be limited to exercise of the powers in C. There's a fairly straightforward reading that suggests that B is a broader and unlimited grant of delegation of power to enter emergency orders. And the reason I raise that is if that is what the legislature intends, then at some point it probably is appropriate to have a discussion about the unlawful delegation doctrine, because it's not entirely obvious how the legislature could, with no standards or guidance whatsoever, simply give to an executive branch official, even a governor, the authority to essentially create law without limitation, to enter orders that have the force and effect of law with no guidance, no subject matter limit, no nothing. I'm not sure that's what was intended, but I think there is at least a language issue there, and clarifying what the intent is probably useful at some point. That's 6 items. I only have 3 to go. Item number 7, there's been a lot of discussion in some quarters about 48939, which is the provision of the KEMA, the Emergency Management Act, that says that all kinds of violations of all kinds of other actions taken under authority of that act are a crime if done willfully and knowingly, a misdemeanor, Class A misdemeanor. That's a pretty sweeping provision. It's original to the act. It was enacted in 1975. It applies not just to governor's orders, but to certain local orders, to certain actions of the adjutant general. And at some point, it probably is useful to have a more detailed discussion about exactly what conduct that criminalizes and what conduct it does not criminalize. And not just in the higher profile examples that have made headlines, but I mean, there have been 30 executive orders issued under authority of 48, 924, 925 since March 12th. I'll just pick on one, and I'm not singling it out for any reason other than it came to mind. But there's the one on alcohol sales that is intended to allow qualifying establishments to mix a drink in their establishment and then put a properly sealed lid on it and carry it out to the curb and give it to a customer to take home. That order suspends certain statutes, which is an enumerated power under 925. It also creates certain new restrictions that you can only sell these mixed drinks at the curb if you do certain extra things. And so what if you don't? What if you're a restaurant, and this hadn't happened to my knowledge, I'm just trying to illustrate the point of how sweeping this provision is. I mean, what if you're a restaurant owner and you take your mixed drink out to deliver it to your customer at the curb, and there are 3 new things in that order you're supposed to do to be compliant, and you only do 2 of them? Have you really just committed a misdemeanor in that event? What if you decide you're going to willfully not comply with one of those 3? Really? I mean, is that really what the statute was designed for? Or for violations of the notary public order, or for violations of the eviction order, or for violations of the foreclosure order, or for violations of the trash collection order? I mean, my only point is that there's sort of an asymmetry between the types of things we normally use the criminal law to enforce versus the much broader scope of things that a governor is authorized to do under the Emergency Powers Act. And at some point, it's probably worth taking a look at how those 2 are designed to work together. Item number 8, this is actually outside the 4 corners of Chapter 48, the Emergency Powers Act, and I only raise it because I know there are people talking about it. It's not something we've focused on extensively at the Attorney General's office, but Chapter 48, the KEMA, is only one of multiple emergency powers statutes on the books in Kansas. You also have, relevant to this disaster at the state level, a variety of authorities, emergency authorities for the Secretary of Health and Environment in Chapter 65. You also have a variety of authorities accessible to local health officials under different provisions of statute. And you have other authorities available not to local health officials, but to local governing body officials to declare local emergencies. And by the way, on the local health statutes, there's a modern version. I think it was enacted in 2005 or something like that. And then there are several, for lack of a better term, ancient versions that were enacted in the teens and 20s, and long before any of our modern development of due process law or modern practices. I'm not suggesting they're infirm. I'm just suggesting they're old and haven't been looked at in a long time. And so, figuring out how all those work together is, I'm sure, a much bigger task than you want to take on before Thursday. But I raise it because it probably is fairly important. And I know there's some interest, more specifically in trying to figure out, all right, going forward for this disaster right now, or at least, after you guys adjourn on Thursday, what exactly is supposed to be the interaction between local officials and the state? I saw a piece of correspondence from a local health officer this week, health officer, not a political actor, but a health officer, to state officials asking that local jurisdiction be relieved of some of the continuing state restrictions under the now phase 1.5 requirements, because in that health officer's judgment, they were unnecessary in that local jurisdiction. And the officer laid out a variety of reasons why they thought that was so. And they wanted to tailor something more specific that in some ways was less restrictive. Maybe in some ways it would be more restrictive, but couldn't do that under the current status of the order in 1.5. So those are policy choices, but I lay it on the table because we're hearing about it. And then the last thing I might just mention, also purely in the policy choice basket, but obviously there is some specific subject matter that the legislature has expressed an interest in further regulating the use of under Chapter 48. For example, I mean, the main one I have in mind is in House Concurrent Resolution 5025. You all included a provision that was on its face intended to disallow any executive action, executive order relating to, I think it was ammunition, if I remember correctly. It was a Second Amendment issue. And likewise, there were the further restrictions that were attempted in 5025 on the exercise by the governor of very specific of those 11 enumerated powers under C1 through C11 in 925. I don't know if you want to do those things or not. I'm just saying that if those are still things that a majority wants to do, you probably have to do it because it's not done right now. It's not an instrument right now that appears to be operable. So I just flagged the issue for your consideration. And with that, Mr. Chairman, I think that's everything I had written down as wanting to offer up, and be glad to stand for questions or go back to work.
Very good. Committee questions. Representative Humphreys, then Keither.
Okay. Thank you, Mr. Chairman. It's Susan Humphreys from District 99. Thank you so much, General, for being here with us. We appreciate it. I had a question on, that you said we would probably want to continue the emergency declaration. And my question is, does that have anything to do with federal funding or the federal declaration? How do those things interact with each other?
Right. Representative Derek Schmidt again. I don't purport to be the expert on that. And I am aware that the governor's office and I think the Division of Emergency Management have been consulting with the appropriate federal agencies that control the flow of money, and they can perhaps speak more specifically. I can tell you my understanding based on having consulted with some federal officials is that because there is a presidential declaration of disaster covering Kansas in effect, that presidential declaration is sufficient under the federal law to maintain ongoing access for Kansas to the FEMA funds, and I think the National Guard Bureau sees it the same way as well. And so what we do or don't do under state law, it's my understanding, is not now a precondition for accessing the federal aid. But again, I want to be very clear. I haven't been on the front lines of answering that question, and I would recommend you address it to the governor's office as well.
Thank you so much.
Representative Keither.
Thank you, Mr. Chairman. Annie Keither, Topeka, 55th District. Question for the Attorney General. I know this, you've given us a lot to consider. And my hand scratching is pretty good, but I can't quite keep up with it. Are you going to be submitting these in writing so we really clearly know what we're talking about? The statutes you're referencing, I think I've got it all, but I don't know that I do. And I would hope that maybe we could get the nine points in question and the information you're requesting we may or may want to consider.
Yeah, Representative Derek Schmidt again. I'd be happy to, and I might say, everybody's been extraordinarily patient through all this with each other, and we appreciate the patience shown to us as we, like everybody, have sort of struggled to keep up with what have been a lot of unusual requests for assistance. One of the current requests we have been asked actually by a whole lot of folks now, some representatives, member of the Senate, a district attorney, for a formal legal opinion on several aspects of the Emergency Powers Act. And we are working diligently to try to get that formal opinion done before you all come back, because I figure it does you more good if we've published it before you get here than if afterwards. The difficult trade-off is I want to be sure it's proper and we've thoroughly vetted it and we're comfortable that our legal analysis is correct, and I don't want to rush it and get something wrong. So, but my hope is, and my expectation as we sit here, is that we will have that issued before you get back. And I think you'll find it's likely to address not all, but most of the 9 points I just talked about in much more detail than we just did. So that was a long yes.
Representative Keither. You're muted, Annie.
There we go.
There you
I know
go.
most people would like that. Uh, I think that brings me back to my original concern that if the Attorney General is going to have this ready for us before we're back on Thursday, maybe not. If he want, I understand exactly what he's saying, and that he wants to do it right. This is our last meeting, so again, if that's ready on Thursday, that doesn't give us a heads up to, I think, correctly address it if we end up addressing this during sine die. So that's my 2 cents.
Yeah, and just to once again say that challenge before us is not easy. I think, as I look through the list of 9, if my notes are any good, I think some of these are not things we're going to be able to address on Thursday. I think we need to identify which ones, if any, need to be addressed on Thursday. And then I know the Speaker Pro Tem mentioned last week an interim committee or somebody to study this before we make significant changes, just because we just don't have the information we need quite yet. So, but we'll get you what we can as soon as we can, Representative Keither. Representative Owens, you're up next.
Thank you, Mr. Chairman. Stephen Owens, House District 74. Mr. Attorney General, thanks for being here. Thanks for your information. I just did want to circle back to your very first point and see if maybe that clarification will come when you're done with your research, and that is it or is it not legal, in your opinion, for the governor to reissue an emergency declaration every 15 days in the event the legislature doesn't extend it?
Yeah, Representative Derek Schmidt again. I think I'll save the bottom line answer on that for issuance of our opinion, because I want to be sure that our team's fully vetted that before I, offer kind of a bottom line conclusion. As I said before, the statute really is silent on that. It doesn't say the governor may. It doesn't say the governor may not. It does create other mechanisms for continuation of a state of emergency without speaking to this one. It's a somewhat difficult question, and maybe I'll just leave it at that until we finish the analysis.
I understand. Thank you very much. And I loved how you called yourself Representative Derek Schmidt. So it's good. Thank you.
Representative Sampson.
Thank you, Mr. Chairman. Thank you, Mr. Attorney General. I appreciate the list, and perhaps not to give you more homework, but one other question I've had raised by a number of people. Is there any precedent or concern to make sure that we're on good legal footing as we start to give any smaller group of the legislative body, whether it's the State Finance Council or the Legislative Coordinating Council, authority to make decisions that are perhaps less administrative in nature as opposed to more public policy making? So one of the other thoughts as they move forward, are we on good legal ground as we do that? And then either way, are there ways that the legislature as a whole or some other group perhaps, but can make those decisions even though the legislature is not in session?
Right. Representative Samsel, Derek Schmidt again. Let me back up and answer those at a kind of a broad level. I don't want to get too far down into it, only because these are novel questions that haven't before presented themselves in the context of a recognized emergency. Nobody's arguing that this isn't an emergency and that extraordinary things are being done nationally, locally, at the state level and need to be done. People are arguing about what the limits on those ought to be and the mechanics, but nobody's sort of arguing the principle. And so, I don't want to go too far expressing an opinion on what might or might not be permissible. I will say that generally, let's go back to what we know from the public record. When you all passed HCR 5025 before you left, and by the terms of that concurrent resolution, attempted to delegate or authorize, whatever the right word is, to tell the LCC, you guys are to do this oversight work, both with respect to extensions or revocations of the state of emergency and with respect to review and potentially revocations of individual executive orders. That was challenged. Obviously, everybody knows the history there. After the LCC voted to revoke a particular order, the governor filed the lawsuit in the Kansas Supreme Court. And we know a couple of things from that lawsuit. We know, number one, that although the Kansas Supreme Court didn't reach and decide the issue of whether the legislature could, by concurrent resolution, authorize the LCC or anybody else to take that action, the governor argued that it was impermissible. That was the nature of the briefing from the governor's legal team. So it's an open question from the court's standpoint. They haven't answered it, but we know at least what the governor's legal position was at the time of that argument. With respect to what the court might think about that question, again, it wasn't decided by the court or any individual member, but we know that Justice Biles filed a concurring opinion that said, had sort of a pithy phrase in it, there's a right way to do this, and this is not it. Which seemed to imply that, and then he actually I think he does say it in a different part of his concurrence, if you'd done that by statute, the delegation to LCC, that would have been fine. It was the act of doing it by concurrent resolution that, in his view, was legally flawed. And I say in his view because, of course, the court didn't actually reach that question. The court invalidated the application of the resolution based on its wording, just said it doesn't apply because a condition precedent wasn't met. So the court never actually said you may or may not, by concurrent resolution, delegate. Justice Biles clearly doesn't think you can delegate by concurrent resolution, but seems to think you can by statute to the LCC. And then you've got the language that I already referenced from Justice Stiegel's concurrence, which certainly does not squarely address the issue, but does pretty strongly imply a view on his part that he thinks there has to be some functioning mechanism by which the legislature can continue to exercise oversight of both the existence of the state of emergency and its use, maybe with individual orders, or else the entire delegation of authority to the governor is suspect. And so, that suggests that, I think his phrase was, there must be a liberal interpretation of those mechanisms. That suggests he might at least be open to an argument that a well-crafted provision would be permissible. With respect to the delegation to the State Finance Council, which was, as I understood it, the other half of your question, obviously that's the mechanism that functions in the statute now with respect to extending or not extending the state of emergency. I don't believe the Finance Council has any statutory authority currently to review or revoke individual emergency orders. I'd want to double check that, but I don't believe it does by statute. But with respect to the state of emergency, it does have that authority. That's been customarily used. It's well accepted. There are in other contexts, at least a couple of Kansas Supreme Court cases affirming the validity of the Finance Council and rejecting arguments that it's invalid on unlawful delegation grounds. So there's some, reasonably strong basis to defend that approach if it's a way you wanted to go, with a properly crafted statute.
Thank you, sir. Thank you, Mr. Chairman.
Representative Heiberger?
Thank you, Mr. Chair. Representative Heiberger, 46th District. Mr. Attorney General, early on in your statement, you used that you expressed concern that the governor's emergency order was not legally infallible. And that's a term I'm not sure I've heard before. And can you give us an example of something in our system that meets that standard other than your own opinions, of course?
Fair point. I may have overstated the standard, but the point, of course, Derek Schmidt again, sorry. The point, of course, is that there is a reasonable critique that the governor's April 30th subsequent follow-on proclamation of a state of disaster emergency was not authorized by law. It's not a slam dunk either way, and as I said before, I've heard the governor's council do it. They can articulate it, as I could as well, in defending it. a very reasonable position as to how the statute does authorize that. It is also possible to articulate a very reasonable position as how the statute does not authorize that. And the bottom line is it's a reasonable debate. And my only point, Representative Heiberger, admittedly perhaps overstated on the legally infallible piece, but my only point was, from my vantage point at least, as somebody who's in the middle of reviewing a lot of this, and then presumably if there's litigation down the road, may wind up defending some of this stuff. If you can take that argument off the table by making clear that the legislature intends that second declaration to be valid, or intends there to be a continuing state of disaster proclamation in effect from March 12th until whenever, that at least takes that issue off the table. That otherwise, maybe we get to litigate, and I don't know how it comes out in litigation.
Any other questions, committee? Representative Carmichael.
Thank you, Mr. Chairman. John Carmichael from the 92nd District, Kansas House of Representatives. Mr. Attorney General, I agree with much of what I've heard you say here today. I do appreciate your years of service in the legislature. I did not know that you were responsible for this statute that has caused us so much trouble. I just put in my newsletter some kudos to you, but had I known that this was yours, I'm kidding you a little bit. Seriously, though, I want to join in my colleagues' request that you try to get us something just as quickly as you can that enumerates the bullet points of your testimony here today. If you give us an Attorney General's opinion, or maybe you'll decide just give it to the Senate tomorrow when they take this up, but if you drop this on us now or tomorrow or Wednesday, it's going to be very hard for us to do anything productive with it. And so just, whatever you can tell us by way of bullet point, this is what I think you got to do. I think it'll help us move forward. And I will appreciate your advisory opinion about impacts and things involved in these statutes, because I think at an appropriate time, it will help us get to where we need to be. Also, Mr. Chairman, with your permission, I think it's only fair to say that in our discussions prior to the passage of the resolution, you also, I think, recommended that it'd be better to do these things in a statute, and I want to give you credit for that. I kind of agree with you as well on that, but as you know, there's practicalities in the legislature, and sometimes when you're trying to work something out with the other house, we can't always do what we might like. But I want to make it clear, you weren't responsible for this ending up in a resolution. I'll bear some of the blame for that. All of that being said, the charge that the Speaker has given our committee is probably threefold, but one of the most important things I think that the Speaker has asked us to address is what happens moving forward with the current declaration, and what happens once the current declaration expires. Let's assume that we don't do anything on Thursday, and that on the 26th, the following Monday, the declaration expires. What are the consequences of that?
Representative Carmichael and Mr. Chairman, Derek Schmidt again, thank you. And before I answer your question, Representative, just a footnote to be clear, and thank you for your kind words, but to be clear, the part of the statute that I had some role in writing is the part we're not using now. It might have worked better. I don't know.
All right, Derek, you caught me. I knew it was the stuff when you and I were graduating from high school that causes the problem, but I had to take a little unfair shot. I apologize.
Not a problem. Thank you. So, Representative Carmichael, let me pull out my crystal ball here. So that assuming that the current disaster proclamation is valid, was validly issued April 30th, and therefore was validly extended by the Finance Council last week, it lasts through I believe it's Tuesday, May 26th, next Tuesday. If it is not further extended in some manner by statute or otherwise, then it ends on May 26th. The statute, KSA 48.924, provides two and only two mechanisms by which a governor's state of disaster proclamation may be extended beyond the initial 15 days that the statute allows. One is by action of the State Finance Council, which may only occur once, and that has already occurred. So it's not an available option for further extensions beyond the 26th. And the other is by concurrent resolution of the legislature, which in theory could happen. And if that's the path that were chosen, obviously there is a solid defense to it. The challenge, of course, is that begs the question whether the proclamation itself that's being extended, the April 30th proclamation, was valid. And for the reasons we've already discussed, that's a debatable proposition. Presumably you can't extend something that doesn't lawfully exist. And so by statute would be perhaps the cleanest way to do it. Now, having said that, what if you don't? I think the answer is if there is no extension tried, then the state of emergency expires on the 26th. Any emergency orders that have been issued and draw their authority from the existence of that state of disaster emergency are become void and no longer are in effect by operation of law. And the question would become, what then happens on the 27th? I certainly don't speak for the governor and don't propose to. I know that the governor's, I think the governor herself, but I know the governor's council in the State Finance Council meeting last week was asked a similar question and expressed what I interpreted to be a view that the governor would at least have the option to issue another state of disaster emergency proclamation. So a third one, if you will. And then you're right back to the questions that surround the second one as to whether that is in fact authorized by the statute. So I do think, and this is just sort of maybe a general statement on my part, but I do think the more successive proclamations there are, the more susceptible to challenge that may be. And I can't point you to a provision of the law that says that, but if one thinks that you're on shaky ground to basically continue an emergency by calling it a new emergency and issuing a new successive proclamation, if you do it once, the ground shakes a little. If you do it twice, the ground shakes more. If you do it three times, the ground shakes. You get the idea.
Mr. Attorney General, and I appreciate everything you say, and I agree with you on those points. But to be more precise in my question, if this expires on the 26th, and to qualify it just a bit, and there's no renewal by the Finance Council, the governor says, I don't have the authority, I can't issue another proclamation. Does that mean that everything simply basically goes away? The orders are automatically rescinded, the state is opened up, the protections that the governor has offered for various businesses and so on through executive orders, that all of those things just expire and we have survival of the fittest?
Representative Carmichael, Derek Schmidt again. I might stop short of that last.
I thought you would. Me too.
Statement.
Me too.
But I would answer the question this way. From the standpoint of the governor's power granted by Chapter 48, the Emergency Management Act, which is what we've been talking about principally here today, I think the short answer to your question is yes. If a state of disaster emergency goes away and there's not some other state of disaster emergency or an extension, the governor may no longer access the emergency powers under 48.925, and any orders that were in effect become null and void by operation of law. I think it's 925B, but I'd have to double check that at the end of the state of emergency. So the short answer is yes, with respect to powers under that statute. Now, I would add some context to that. As I mentioned before, there are multiple emergency powers statutes that authorize different people to do different things. So the local statutes, for example, would be undisturbed. at least directly, by the expiration of the governor's orders. The one
You mean
possible
the
exception.
authority of localities under the statute?
Yes. Now, there may be some
Okay.
practical impacts on that. For example, I think one of the governor's early orders was to essentially, my words, not hers or the order's words, but essentially waive a statutory requirement that the locals have to re-up their local state of emergency with great frequency. I forget what the statute requires, but they got to do it. Their leash is shorter than the one that's built into Chapter 48. She waived that so you don't have all the locals having to go out and renew their emergencies every, I think it's 3 or 5 days or something. And presumably if her order went away, the locals would default to those statutory requirements. So I'm not saying there'd be no impact on the locals, but their basic authority would remain. And likewise, the basic authority of the Secretary of Health and Environment for contagious and infectious diseases would remain. But to be clear, and any federal authorities would remain under federal law. But to be clear, the governor's authorities, at least under Chapter 48, or at least under 48.925, would no longer be available.
And my final question, with your leave, Mr. Chairman, is the statute that we did pass at the request of the Chief Justice and the courts also has triggers, as I recollect, based upon the expiration of the governor's declaration of emergency. And that causes me concern because I'm not sure that the court is prepared to resume business as usual a week from Tuesday. And without getting you in the policy realm, but do I interpret that correctly, that if the governor's declaration goes away, then we have the problems back in our lap that the Chief Justice brought to us just before we left?
Representative Carmichael, Derek Schmidt again. I do think it is correct. My recollection of that statute related to the courts is that it is, at least in part, tied to the existence of a gubernatorially declared state of disaster emergency. So, yes.
Yeah, and my recollection is that there may be a 150-day extension on speedy trial, but elsewise, we put the courts back where they were when the declaration expires. I really appreciate your help, Mr. Attorney General. Thank you very much.
Thanks, Representative.
Okay, committee, we're going to let the Attorney General off the hook for any more questions and move on because we have Will Lawrence, the Chief of Staff for the Governor, here with us today. There he is on my screen. Couldn't find him for a second. Thought he took off. Mr. Lawrence, the floor is now yours.
Thank you, Mr. Chairman. Thank you, members of the committee. I'm glad to be here. You've got my written testimony I submitted this morning. I'm not going to go through a lot of that in great detail. I think a number of these items have been covered in terms of the current status of the governor's declaration issued on April 30th. I will say, there's a lot of discussion about what that declaration was doing, and I've heard the word extending being used. And this was not done in an attempt to extend the March 12th declaration. It is a new declaration based on the emergency conditions existing on April 30th and going forward. So I just wanted to clarify that a little bit. I think I'm going to spend the bulk of my time really talking about what happens if this declaration goes away. Certainly with what the Attorney General stated, to the extent that there's an ability to go back and retroactively extend the March 12th declaration, that would be certainly the preference of the governor. Thinking back to the discussions and when we got into the back and forth of the HCR 5025, when things started changing in it on the Senate side, the big thing that I cautioned was the ability for the declaration to remain in effect. And I cautioned that May 1 probably was not going to be sufficient. And the reason for that, I use the example in my testimony, is going back to last year with the flooding. One of the things that we also extended the declaration through a joint concurrent resolution to, I think, the second week of January the next year when the legislature came back into session. And the reason for that was if the emergency situation had dissipated, then the governor could end the emergency. But since the legislature was going to be gone, and we did not know how long the flooding was going to occur, but we knew it was going to be going for a long time, this would get us through until they came back, until you came back. And then there could be a discussion about, does it need to be extended, or can it be allowed to expire? And by the end of the year, most of the flooding situation had kind of gone by the wayside, but we still had activity going on where we were hauling water for a community in Jefferson County because their water treatment system had been inaccessible due to the flooding. And we were doing that for most of the year, and we have to have a declaration at the state level to be able to do those type of things. And so that's the same thing here. In 99.9% of state emergencies, when you're talking about tornado, flooding, fire, executive orders are not necessary. We're really in the 0.01% situation with the COVID-19 pandemic. And so that's raised a lot of these questions. And so everyone's focused on the executive orders. I would submit to you that there are a number of these executive orders beyond the ones that have gotten a lot of attention and that are really important. And I know you have the full list. Touching on the discussion from General Schmidt on the local disaster emergency orders, those are required to be done every 7 days. And so, we're able to let them go to having one and not having to renew it every 7 days. And I know that was important to each of the local counties. I think we have 84, 85 counties that have a declaration in place now. And the existence of the state and local declarations are very important for this process, because when we think about the things that have been requested of the state so far in this pandemic, there are quite a few of them, but PPE has been a big discussion. And the way that works is at the local level, the local unit of government of the county will exhaust their resources under their declaration. Under the state declaration, they will put in a request to KDEM. KDEM will then fill that, and the county then uses that to provide it to whether it may be a hospital, their health department, maybe some critical infrastructure employees, first responders, things like that. And that's all been ongoing. And having the declaration in place allows us to do those type of things. Additionally, members of the National Guard have been used in various ways across our communities, whether it's helping deliver food. We had some outbreaks in some of our food pantries across the state. We used National Guard individuals to help with that. We've been doing drive-through testing in some of our communities across the state. We're using the Guard to do that. And we even have some of them helping out at Lansing with some of our staff being out due to COVID being in that facility as well. So those are all things that are being done under the state declaration that need to continue. And those type of activities we anticipate will need to continue for quite a long time. And in terms of the federal funding question, we did have lots of discussions with FEMA, National Guard Bureau, and several other entities and staff. And we got to a place where we were certainly comfortable with FEMA that the presidential declaration that is in place, it's for all 50 states, and it is ongoing. There is no end date in that declaration, which allows FEMA to continue to do what it needs to do on that front. We got into a discussion with NGB about whether or not the Stafford Act required there to be a state declaration in place for Title 32 status. that's the 502F funding, which allows members of the Guard to be essentially on the federal payroll, but still under the authority of the governor to do some of these things that they're doing. We got to a place where they were comfortable that with the way the presidential is set up, with the ongoing basis, and that we had a state declaration in place, may have with that one, and then with the one in April moving forward, certainly gets us to the end of May. And then, I'm not sure where things reside at that point in time, but we are making requests for the Title 32 status to continue. Right now, it goes until I think June 24th, and we're asking that to go until the end of July, along with a number of other states. So there are, in terms of the federal resources, we think those will remain in effect for at least a period of time. Right now, it's unknown how long the presidential will be in effect. But that's only one piece of the puzzle here, as we think through all the things that are going on that, most of the time we're still not talking about now, but, we're not talking about most of the time because they're being done for local communities, and there may be very unique requests that come in based on a need in their county. And we're able to provide that under the state declaration paired with the local declaration in that county. And so that's been part of the state response plan, and it continues to be. And so that's why we need to keep that declaration in place. In terms of changes, a couple of things I would note on that point. Time is short, with the legislature only having one day to take action on the floor of each chamber. And so, certainly the governor's request would be to ensure that the declaration, whether it's going back and retroactively extending the March 12th or extending the April 30th, that needs to remain in effect. So certainly a joint resolution, or if it needs to be a statute to accomplish that, that would certainly be the request. To the extent that the items that the Attorney General raised are going to be addressed, certainly would caution the more things that you try to take on right now, the more likelihood that something may be done in haste that may not be fully vetted or contemplated. And I think that's the last thing anyone wants to have happen here. And so, the governor certainly would support what the Attorney General touched on in terms of taking the ability to do rolling extensions, like what we do for infectious disease in animals. That concept of State Finance Council, the governor would certainly support if that's the route that the legislature chose to go, to allow us to, and that's a situation that I think makes a lot of sense, because every 30 days you are assessing the state of the emergency and making a decision to extend or not extend with the members of the legislature on the Finance Council. But that is, we get too far beyond that right now. There's a risk that we start putting a lot of stuff in there without fully thinking through that. And the governor has stated this, and I will reiterate it, certainly welcomes an interim study to look at the best way to make changes to KEMA, because there are a lot of things in here that need to be discussed. These are, again, we've been dealing with fires, floods, and tornadoes. Pandemic hasn't been something that any of us contemplated. Certainly I didn't contemplate it when I accepted this position. And that has presented a lot of challenges in thinking through all these things. But I think given what we're dealing with here, and not just with the governor's authorities, but again, thinking through the other statutes with local orders and some of those issues, I think there needs to be a very thorough discussion and vetting of those items before we enact something long term. So that would certainly be my caution on behalf of the governor as we move forward to Thursday and what the legislature may consider. or may not consider. There were a couple of questions that I noted that I was going to touch on. I just wanted to make sure that I address those in my testimony here. And I think I address the federal funding question. I think in terms of the question about, what the governor will do March 26th, depending on what happens with the legislature, I don't know. Certainly when I went before the LCC on April 22nd, I expressed that similar concern that what I knew was we had a declaration in place till May 1, and that needed to be extended and it needed to continue. And that was certainly the preference. Understanding that in that situation, we're still dealing with the pandemic, but April 22nd was still, back when we were still in the process of peaking as a state, and there are a lot of safety issues with reconvening the legislature then. Don't question the decision to not return prior to May 1, but thinking back then what the ramifications for not extending that the declaration was going to be, and thinking through how we would do that. And I certainly would point to, I think the different discussions around, doing the continuous 15 days and how that kind of skirts the statute. I understand that argument. Certainly in this scenario, we're looking at a situation where the legislature was unable to come back. They were scheduled to come back prior to May 1. And, based on the conversation that I was having with leadership, there seemed to be, some discussions about how we might address that, but there was no ability to come back. And so that created a situation that I don't think anyone contemplated, but just made this even more unprecedented than it already was. So I think there's a lot there that's different. And the state of the emergency still, I think, very clearly existed. It had not gone away. The governor is charged with, in this emergency situation, with if there is an emergency situation, she's required to declare that. So we certainly have the position, understanding the Attorney General being able to argue both sides as a good attorney can. We certainly take the position that the governor was within her authority to issue the April 30th declaration. With that, Mr. Chairman, I'm going to yield for any questions that many members may have.
Very good. Thank you. Any questions for Mr. Lawrence? Representative Garber.
Thank you, Chairman. Thank you for coming, Mr. Lawrence, and being with us today. I was reading your testimony that you provided us, and I appreciate that. You explained it very well to me. I did have a question on page 2 when Mr. Day talked about the representatives and senators that are at risk. I don't know that I've ever seen a explanation of what at risk is. I know that everybody can get this, but can you explain that to me, or if you don't have it with you now, if you could find out and give that to us later, I'd appreciate it. Thank you.
Sure. What I think I'll probably best do is email the definition. I certainly am not a medical professional. I've spent enough time with Dr. Norman now that I think maybe he could give me an honorary degree. But when we're talking about at risk, we're looking at a number of factors. One of them is certainly age, and 2 is underlying health conditions. And so I was not part of the discussion as to who fit within those categories. That was just information provided by Mr. Day at the LCC meeting, and I wanted to include that to underscore that this was a unique circumstance. And I think a lot of thought went into making the decision about whether or not to come back on the 27th. And that's certainly why I don't question that decision. But that came from Mr. Day and his numbers. But I will be happy to send around the definition that's used by KDHE and CDC and others on at risk.
Okay, well, I appreciate that. And, you know, I can't speak for Kansas because I don't know of the deaths, how many have had underlying conditions and things like that. But from what I've seen throughout the world, it appears that those with underlying conditions obviously are more susceptible to having their life ended because of this, not necessarily because of the virus, but it just adds to all their other problems. So thank you very much. And I appreciate it if you get back to me with that. Thank you. Thank you, Mr. Chair.
Further questions? Representative Humphreys.
Thank you, Mr. Chairman, and thank you, Mr. Lawrence, for being here. I just had a question I was wondering if there's any thought to, or I guess I'm just asking, is this possible? As I read through the statutes, I noticed that they mention areas that are affected by the proclamation in different ones. And so I'm curious, is there any mechanism to declare an emergency just in certain counties? Because we know that, 85% of the counties have 20 or less cases. So I'm just curious, if you're thinking there's a way to avoid the one size fits all, but if maybe the governor would be able to tailor it more towards the different counties and areas that really are having issues.
Sure, and Will Lawrence again. I appreciate that, Representative. We have had some of those conversations, and that's kind of in some ways the approach of what we're trying to get to with the reopening plan is getting to a place where you have kind of that ceiling where you get to 30, 90, where there's a lot of comfort there that gathering that size isn't going to cause a lot of problem. But then it's up to locals to make decisions on how they're going to operate. It's been pretty limited with the exception of phase 1.5. There were a few items with like gyms with the in-person classes and the locker rooms. But for the most part, it's been doing things like allowing the counties to make the decision on what businesses would open and not open beyond what I apologize. I've lost my train of thought there for a second. So to get back to what we're talking about here, it's letting the locals make a decision within that framework and trying to get to a place where once the businesses are open at the state level, then a local decision can be made whether or not they should actually open or if they should be more limited. And let's use restaurants, for example. We didn't put a percentage capacity on a restaurant, but a local unit of government could say, well, instead we want to go 25% seating capacity. And I think that may have happened in some places. So we're trying to set that ceiling. And in terms of looking at things on a county by county basis, if we get to a place where I think what we're trying to avoid is having to take the state back to a stay-at-home or a more limited approach on being able to reopen. And so once you get the state open at a certain level, if a county has a bigger problem, then that county can revert backwards. So I think we're trying to accomplish what you're asking, just in a little bit different way.
If I may, Mr. Chairman. Yeah, so I understand that counties can be more stringent. But my question is there a way for them to be more lenient? And I'm actually looking at 924D, and it just, I'm only bringing that up because it mentions, disaster plans applicable to political subdivisions or areas affected by the proclamation. That's just one sentence, and it made me wonder, can there be a proclamation that only affects certain areas? So it's kind of two questions. One, could local jurisdictions be more lenient? And two, could there be a declaration that was limited to certain, it's not statewide, but it's a proclamation, areas affected by the proclamation, as I'm reading here in 924D. Any thoughts on that?
Yeah, I appreciate that. What I will do is I'm going to flag that section for our council to review, and we'll come back to you on that. I understand what you're saying now. And certainly that's been a little bit of a challenge when we looked across the state at there are counties that don't have cases, don't have hospitalizations, or have very, very few. And at a certain point in time, part of the concern was they don't have them because of the amount of testing available. But we're obviously solving that issue, and so that trend is very important. So I'll have our council review 924D, and we'll get back to you.
Thank you. Thanks. Thank you, Mr. Chairman.
Further questions? No waving hands and no blue hands. I think we are done with questions. Thank you, Mr. Lawrence.
Thank you.
Okay, committee, this is the closest we've ever finished a 5 o'clock in like 2 years. I appreciate everyone's questions. I encourage you all, if you have time tomorrow, I believe 9:30 in the morning, Senate Judiciary comes back in. You don't have to watch them. You can just turn them on and listen to them when you want to. I keep them on in the background and try to pay attention most of the time. But I would encourage you to do so because they're taking this very same topic up tomorrow. I'm not sure what their plans are for conferees or conversations or anything at this point. I'll call the chairman later tonight and talk through what his plans are. But then as you hear the meeting tomorrow, what they have to say and anything else, the Attorney General issues his opinion, those types of things, any feedback to me, Representative Carmichael, would be beneficial. So as we move forward, we can do our best job of getting information back to you and make decisions on this very short timeline. So yes, Representative Carmichael.
Fortunately, I'm able to do this every year. This may be our last meeting together this year, and I want to express my appreciation to the chairman, the vice chairman, for the good and bipartisan and friendly way that they're able to work with me and with my caucus. And to those of you who I was a little tough on when we were in hearings, you have my apologies, but I think we ought to all be proud to be a member of this committee. Thank you.
Good point. Great committee. I enjoy coming to House Judiciary Committee, but you are all such a big help as we try to address these issues. I mean, we do good work. We take our time. Sometimes we argue and fight a little bit, but we come up with good products, and most of the time it passes darn near unanimously because of the work we do in committee, and I appreciate that. Well, if there's nothing else, yeah, Representative Berquist. Ah, you're muted.
Unmute.
Oh, you unmuted and then muted again. There we go.
Okay. If we listen to the Senate Judiciary and end up with more questions than we do have answers, is there a possibility of us meeting again at your discretion?
Not really so much. It's more the speakers, but yes, let me know that and I will make that request and we'll figure.
Thank you, sir.
Yeah. Okay. Well, thank you all. It's 5 o'clock. Time we always finish. Good to see you all, and I'll see you on Thursday, if not before. Thank you.